speculative activities that fall under the mechanisms of carbon markets do come with a very heavy toll for human rights. Before continuing, maybe a couple of housekeeping rules. This event is being live streamed, but I would only ask those that are authorized to take pictures. Otherwise, please do not take any photo of today's event. You will be also finding the recording on the Geneva Environment Network website. So maybe taking a step back. So what are carbon markets? We will hear more from Ghazali in a minute. But first of all, just to give a bit of a background, these are trading systems in which we have carbon credits that we are generated primarily from greenhouse gas emissions that are supposedly reduced or permanently sequestered, which are bought and sold by countries, by individuals, by companies to compensate for their own emissions. And so today we will be exploring two dimensions of these mechanisms. On one hand, why and how they are not a viable solution to reduce greenhouse gas emissions. And on the other hand, what are the human rights impacts that occur when such markets are in place and revenue-generating activities do take place on the ground. So without any further ado, over to Ghazali. You have been working on carbon markets for a while. You speak also on behalf of your local government as an indigenous representative. So can you please tell us not an effective application approach?
Thank you, Francesca. I think if I start explaining it, then we're probably here for the rest of the day. So I'll limit it to like seven reasons why to answer your question. But I think it would be good to also to backtrack it a little bit. Carbon markets is now a hot item, particularly after the Paris Agreement. There is a agreement, Article 6, assumption of new carbon market. But before Paris, you had a free development mechanism on a Kyoto Protocol. And from an indigenous people's perspective, there was a lot of challenges when the CDM protocol was established. For that brought a lot of criticism from indigenous peoples on this mechanism. Obviously, the human rights impacts. We saw that some projects were associated with involuntary resettlement of indigenous peoples and significant social and environmental harm. And brings me to the second point, which is environmental integrity. There's a lot of issues with environmental integrity because there's an additionality and the permanence of emission reductions. There were a lot of concerns about that. The third one is the inequitable distribution of benefits. Large corporations, wealthy countries, often benefited more than indigenous peoples, even though most of these projects were on the lands, territories, and resources of indigenous peoples. And most of these projects occurred without the free, prior, and consent. Which brings also to the fourth point, the lack of meaningful participation. Indigenous peoples, most of these CDM projects were often excluded from decision-making processes. I often compared CDM with Article 6, then this is CDM, the amount of projects that are under the CDM. Then the amount of projects that can be developed under Article 6 is the Lake of Geneva. Just to give you a perspective of what impact can be. So Article 6, what it was meant to be was, well, let me back up that as well, is like many of your member states had your NDCs, national determined contributions, and how can you help each other in terms of achieving your NDCs? And that's where Article 6 came into play. International cooperation. That's the official designation of Article 6. But actually, if you look under the hood, it is a new carbon market. It's actually not exactly new. It was supposed to be new, But the danger is that it can become a CDM 2.0. Without human rights safeguards, without the participation of indigenous peoples, it could, and without effective measures to ensure environmental integrity, it could become a CDM 2.0. And well, I think we all agree that when we all went to Paris, that the objective was different. To stop climate change, to mitigate climate change, to fight climate change. Actually, from these people's perspective, to avert climate change. 80% of the world's remaining biodiversity is on our land, territories, and resources. And we did that without any AI, ChatGPT, or whatever, actually, to protect the biodiversity. So we have a lot to contribute. So what we did in Paris was ensure that human rights-based approach was integral to the agreement. Well, we all know that it was not didn't go as people wanted to. A lot of people wanted, well, civil society and indigenous people wanted to have human rights in the objective, purpose. Instead, it became a preamble paragraph, the famous preamble paragraph 11 of the Paris Agreement. Then it took years, actually, when they operationalized the Article 6 carbon market, and with civil society, CL, and indigenous peoples as well, to make sure that there are three elements into this carbon market, into Article 6. One is the human rights-based approach, safeguards. The second is full and effective participation of indigenous peoples when it comes to the project development, the project design. And the third one is to have a appeals and grievance mechanism, access to justice, making sure that even though it's not mentioned verbatim into the entire text, but that there's always these human rights-based elements like access to justice into the text. But this is all actually to make sure that it doesn't become a thunderstorm, or pardon French, shit show. There are many concerns that indigenous peoples have with carbon markets. I've already explained the CDM, but it is very important that, and many of your member states have adopted the UN Declaration on the Rights of Indigenous Peoples. And the problem is that the carbon markets will have pose significant dangers to the implementation of the rights of indigenous peoples under the UN Declaration on Rights. So I promised you some reasons why carbon markets are not effective mitigation approach. First one is obviously the human rights violations. We've seen, for example, the Barra Blanco Dam project in Panama, which led to the displacement of indigenous peoples and the loss of their livelihoods, and that is just tip of the iceberg. There are many other examples all over the world, and we're fearful that as we further this carbon market without significant safeguards, that it will have a snowball effect. There will be many more of these situations. Environmental integrity. Integrity is the second. They fail to ensure real, measurable, long-term reductions in greenhouse gas emissions, because it is, if you look at it, it is an accounting mechanism, net zero. You do a little bit more, I do a little bit less. At the end, we meet each other in the middle. The third point is double counting. That's very technical, I apologize, but please keep an eye on the risk of double counting emission reductions when we discuss carbon markets. The market is also, fourth point is it's very volatile. It can be very volatile and it will be volatile. Different speculation that has already been happening. And you want a market to be effective to participate in it. So this market volatility is a very important part of it as well. The distribution of benefits is also a problem. And usually exacerbates existing inequalities and fails to support sustainable development in host countries. The other point is also technical. It's a very complex mechanism, and people can get very lost in the woods when it comes to that. And there's participation of these peoples, of civil society, it becomes a problem. And and I'll go to that later on probably, is that the lack of transparency and accountability. In this, there's a lack of, as Article 6 is being developed right now, lack of transparency when it comes to the exchange of carbon credits, and it makes it difficult to ensure that projects actually deliver on emission reduction and environmental integrity. So to just wrap it all up and package it for you, is that these issues that I highlighted are just 7 of many more, but it also highlights that there's a definite requirement for this carbon market under Article 6, or the voluntary carbon market that's being created as well, outside of the UN scope, to have robust safeguards. We cannot have a market mechanism, or let me put it differently. We cannot have climate action without robust safeguards on human rights for these peoples, and implement alternative approaches to reduce the carbon emissions, rather than a market mechanism. Thank you.
Thank you very much, Ghazali. As you say, it's definitely a complex concept, but it's important to have these conversations to start unpacking all the challenges and the stakes that are there when we discuss carbon credits and markets. And you touched base a lot about the human rights violations that occur on the ground. And we're particularly happy to have with us today Richard and Anna Maria, because they will be presenting reports on case studies exactly that show the toll on human rights that some of these activities take. So over now to Richard. Human Rights Watch has recently released a report titled "Carbon Offsetting Casualties," violation of Chang indigenous people's rights in Cambodia's Southern Cardamom Red Plus project. The title is quite long, so you will help us unpack it. But the study assesses the impacts on the rights of indigenous peoples in one of Cambodia's largest carbon offsetting projects, highlighting the human rights abuses that this project involved for the affected communities and the violations that are still ongoing until now. So over to you.
Thank you very much, Francesca. Ladies and gentlemen, lovely to be with you this afternoon. Thank you to CL for hosting this along with FIAN, for partnering on such an important issue here. What I'd like to do with you this afternoon is to take you through a piece of research that Human Rights Watch has worked on over the last 2.5 years, a very specific project in southwest Cambodia. And to situate this presentation together with Ghazali's 7 points, this is essentially number 1 of the 7 that Ghazali walked through. There's many concerns around this particular mechanism. One of them is that it is driving human rights abuses on the ground, particularly against indigenous people. We haven't researched, haven't spoken to issues around whether or not there is integrity in the market in other places. Other scientists and other organisations are well placed to speak to those issues. But before we talk a little bit about the research that Human Rights Watch undertook, I did want to start today's presentation with a note from some grim news from Cambodia. Earlier this week, 10 environmental activists with a local environmental group called Mother Nature were convicted by a court in Phnom Penh of plotting against the country, and have been sentenced to between 6 and 8 years in prison. 4 of those individuals are currently in prison. So that gives some indication around the political environment and human rights environment in which these sorts of projects are moving ahead. There's an extreme pressure on civil society inside Cambodia, and particularly its environmental civil society. At the same time, Cambodia is incredibly eager to expand and to benefit from the carbon offsetting market. And it's trying to do those two things. One, crack down on local groups and environmental offenders, as well as profit from markets. So the piece of research we looked at was in southwest Cambodia. It's the Southern Cardamom's Red Plus project. We worked on this for over 2 years, visited 23 of the 29 villages inside the project area, and did approximately 90 interviews with concerned villagers living inside the project area. The research focused on an Indigenous people, one of the many Indigenous peoples in Cambodia called the Chong. Many of those have not been, many of those individuals and communities have not been, do not benefit from formal title, particularly not formal community title. And that's important as this story unfolds. It's important to recognise that the Chong have been living in this particular part of Cambodia for a long time. It's impossible to say for how long, but if you go back to colonial era maps of the 1850s and 1860s, you'll see references to villages with similar names to those same villages in the areas today. So there's a long history of Indigenous occupation in these areas. And then the carbon market issue sort of exploded in the same area. The formal start date of this particular project is difficult to formally to ascertain. Formally, the project began on the 1st of January 2015. It's a huge area. It's 500,000 hectares of forest, but also in places inhabited forest. And the carbon offset project is run jointly between Cambodia's Ministry of Environment and a local conservation organisation called Wildlife Alliance. The FPIC meetings with Indigenous communities began in August 2017. And if you've just spotted that there is a gap between when the project started and when the FPIC meetings started, you're right. There was a 31-month gap between the formal commencement of the project and the first FPIC meetings with local communities. When in consultation with the environmental organisation that runs the project, we explored this and tried to understand why. They would say, well, the real project began in sort of August 2017, and so we technically backdated it to the 1st of January 2015, those 31 months. And so really the project began in 2017. That position is not substantiated by the findings. So in that 31-month period, a lot of consequential activities took place in this project area. The main one was the establishment of a very large national park right inside the project area. So in other words, before consultation meetings had begun with local communities, the environmental organisation that was the proponent of this project had proposed for a national park to be created, which happened in 2016. And under the rules of that national park, Indigenous people, including those living in the project area, could not farm or forage as they had been doing so for a considerable period of time. Also consequential is that from that project start date, the 1st of January 2015, the project proponents are making money. So it's issuing credits, the project, and projects being bought and sold on the basis of those credits that had happened, that were issued before FPIC meetings had begun, just to give you a sense of the violations. The second main finding was of the research, so that's a sort of a technical one, but it gives you a sense of how essentially this whole process of FPIC, and we should be actually exploring local communities' use of land and their titling of land, happens essentially as an afterthought to the creation of the national park and this particular project. The second was that having created the national park and having a project area established, supported by the Ministry of Environment, organisation rangers and Ministry of Environment rangers then carry out abuses against the Indigenous peoples who are living in this area. Those abuses are essentially two forms. One is a criminalisation of traditional ways of farming and foraging. So when people enter into those forests, they are then subsequently arrested. Also, forced evictions. So we documented 6 instances in which people had been residing in a particular area and their houses were destroyed and they were forced to leave that particular area from Ministry of Environment officials. So it's hard to see how, from an outside perspective, these issues are allowed to continue until Human Rights Watch comes along and starts to document them. In other words, if you look at the paper record, this is a high-profile carbon offsetting project and is verified by the largest carbon offset verification organisation, Verra. And Verra has, until we are investigating, Verra has certified this project under 3 of its certificates. So it's had a series of auditing companies look into this particular project. And sometimes some of those audits flag issues of concern, right? So they flag, for instance, that fact that FIAN began 31 months after the formal commencement of the project. They're identifying some of the issues in the project, but nothing really happens. There's no consequence to that. There's a paper trail, but nothing's actually actioned by Verra, the certification company. And then other issues, such as forced evictions, are not identified by the auditing companies and the verification organisation. So the third finding is essentially just one of systems failure. So in other words, the organisations that are certifying integrity in terms of the human rights standards around these organisations are certifying there's no problems there, although evidently there are. Very briefly to conclude, Verra has suspended the project since we communicated our initial findings. They are still technically investigating. They've been doing so. We released our report over 5 months ago now. They are still investigating the project. But I think there are 2 really salient points in terms of how this will play out in the future. The first is if we are seeing widespread violations of FPIC in these projects, what does that mean for how the projects continue? So in other words, project proponents would say, well, surely there may have been some concerns around the project, but can't we just keep going? Right? And the problem with that is that if you haven't secured initial consent prior to the commencement of the project, then you don't have a small technical problem around the edge of the project. You have a fundamental problem with the project at the heart of it, which is that you've created an entire structure without ensuring that the local people have agreed to that. So what does that mean 5 years into a project? And how do we start to remedy the fact that for 5 years a project has been operating without the consent of the people who were there before the project began? And the second worrying trend worth highlighting moving forward is around the advocates for this project. They will often advocate. We're currently in a conversations with the organisations who want this project to continue, and they will be saying, but what about the benefits of these projects to the local communities, etc., etc., etc. And what you often see is an instrumentalisation of concern for Indigenous people by the project benefits, by the project proponents. And the important thing to keep in mind when you see the instrumentalisation of local Indigenous communities as the reason why these projects need to go forward is ask the following question. Is there a benefit sharing agreement between the proponents of the project and those local communities? In other words, are you actually ensuring that the benefits of this project flow to those local communities? And if so, under what conditions? And to this day, there is no benefit sharing agreement in this particular Palm State project. I'll leave that there.
Thank you, Richard. I think also the fact that the certifying company decided to suspend the project testified the importance of organizations like Human Rights Watch and FIAN to really shed light into what's happening on the ground and shedding light on the structural flaws, as you were saying, of these systems, not just in terms of the fundamental rights that are talking about forced eviction, the right to food, right to life, even. But also procedurally, once again, how do we ensure that the free and prior informed consent of the indigenous peoples is not just a part of the box ticking exercise, but effectively implemented. And then all the question of corporate profits is of course, the benefit sharing, so that we can also include these projects as a way for meaningful human rights compliance development at the local level. The case study has been now presented by FIAN, of course, in a different region. We're talking now about Colombia. And I think it complements well what Richard has just explained, because once again, you also looked at substantial rights violations, but we also see, because of the specificities of the project that you're looking at, how artificial intelligence plays into that and what the risks of traditional credit generating activities are and how they are multiplied by digital markets. And that, of course, entails questions around data, information sharing, which companies own which information, and so on. So the report that FIAN International prepared and just released is called Coffee and Carbon in Colombia, Human Rights Concerns at the Intersection of Food Systems, Climate Change and Database Technologies. So over to you. I understand we have some slides, so please show them. Perfect. Over to you, Ana Maria.
Thank you very much, Francesca. I join Richard in thanking CL for putting this pertinent panel together and giving us the opportunity to present our last report, which has been written by FIAN, but with the very specific contribution of Maela, which is the agroecological movement of Latin America and the Caribbean, with over 200 organizations of peasants and indigenous peoples. So it's really a participatory action research that we did with them. And the idea of this report is to sound the alarm on the risks of carbon markets for another group. This time it's not for indigenous peoples in the forests, but for small food producers in the places where they cultivate. In this case, it is cacao and coffee plantations. And this warning that we do is interesting because in our knowledge, this is the first time that, as you said, Francesca, we take the carbon markets with all the criticism that our two panelists did, very agreeing with them. But we look also into peasants, which is a group that has not been very present in the environmental work, even if it is improving now, and connecting to the digitalization, which is a very new topic, and it's not very normal that those working on the environment also work on digitalization. So we are trying to build up the bridge and show the problems. And I want to emphasize a bit, expanding what Richard said, that the problem that we see in this approach to the environment is that the environment is put in the sense of the capital system, which means natural processes, ecosystem processes that are anyways there because the forests are there and the people live in them, or the people are cultivating, are transformed in environmental services that are financialized and now digitalized. And this means that instead of respecting the nature and its processes and respecting the people and the relation they have to nature, they are like linked to the value chain to produce more profit, which is the problem that we see in this system. Our case study happened in the coffee plantations in Colombia, in the coffee zones, and it exactly connects the smallholder farmers to the global carbon markets in a financialized structure by the Rabobank, which is a bank from the Netherlands, using a digital platform, which is mainly from Microsoft. So we have big powers in the global digitalization market and financial market, and the food producers who live in the territories and maybe are not aware about these dynamics. And everything is managed by a non-profit organization called Solidaridad. And the big promise is that the people will get additional income for continue planting their coffee and cacao as they have always done, promoting agroforestry. So imagine in a country that is going out from a war where there is big poverty and somebody comes and tell you, we will give you money, 20% or 10% of the carbon credits that we sell, just for do what you have been doing. It sounds very attractive to people. And all this happens through this Acorn digital platform. So what we did was to interview peasants to understand what was happening. And these were our key findings. So first, that the carbon markets are very problematic because they depart from problematic assumptions, as Gasly presented. Some problematic assumptions are the idea that these plantations will equalize to the emissions of the fossil fuels, which is not proven. And in this sense, the questionable climate benefits, also looking into the future, are big. And of course, there are risks for the human rights of peoples and communities, in which the market solutions put profit over human rights. And of course, the new thing here is that now we are passing from the indigenous people situation to the agricultural lands and ecosystems that are managed by these small-scale food producers, putting their human rights at risk, and presenting that as a climate solution. So what we found is that this model creates wealth extraction, exploitation, and is a new way of colonialism, where these technologies that are used to measure the carbon storage and trade and the carbon credits are a way to exercise power over the people without the people knowing. There is this new term, the things of internet. And many of the data that the peasants have, like their personal data, their territorial data, are being taken because they are needed for the artificial intelligence analysis that will be done later to calculate how the carbon storage works. And as Gasly said, the carbon markets as such are already very complicated, but now we add a new layer of complication, which is the technological structure and the opacity and increase of the power imbalances that creates. So people are in their territory, there are drones around measuring the land, there are other geographical georeferentiation. All this works through the different chains that we have in the internet. So it makes the thing very difficult to understand, even for us. And one of the big problems is that even, of course, Colombia has a very interesting legal framework respecting all human rights, there are not specific normative frameworks to prevent the human rights violations created by this new model. So we have a good intention by the Colombian government, which is decarbonize, which is the energetic transition, but the legal frameworks are not going hand in hand. And of course, in this way, the obligations to protect the peasants' communities is not met in the best way. Then, when we collected information from the peasants, what they said is that they lack information, so they are not totally aware which are the implications of all this data collection and of the very informal agreements that they have with the company. There are no independent complaint mechanisms. So when we asked the Solidaridad, which are the complaint mechanisms, they said, we have a WhatsApp group. So these are the complaint mechanisms. And we have observed that there are already some changes in the farming practices, because if the peasants cultivate plants that grow very, very quick, they can show more emissions and then they hope to have more benefits. So there is distribution of benefits, not proportional, and they try to get more, but this changes the entire ecosystem. And of course, when all the data of these people are taken off, extracted, a big concern that we have is the loss of autonomy, even to decide how to use their lands in the future, and self-determination. So I will let that now for the moment, but I also left some pages at the entrance with the QRs, the report. The report is very detailed, also the information we got from the peasants, and you are invited to go into our webpage. Thank you very much.
Thank you so much. I want to give the time also for the special rapporteur to provide some reflections, but maybe just a quick follow-up question for you and Maria. We see what the structural problems are, and also sometimes we have governments who will to make things right, but then, as you say, the legal policy and legal framework is what's missing. So what would we need to be in place? What kind of measures should be there? Is it a problem of enforcement, or should we need specific measures and policies in place?
Yeah, we think that it is important to have very specific legal frameworks. It's not enough with those what we have, even if we can try to, defend people with those. Of course, implementing the UN Declaration on the Rights of Peasants, which has been included in the Constitution in a way by the Colombian government. The Colombian government says it's very important, the parliament in reality. It is very important that these legal frameworks take into account the right to self-determination over data, which is similar to the discussion here in Switzerland around digital sovereignty that is being to be put in the Constitution, hopefully. And also maybe take into account the recommendation of the Special Rapporteur on Indigenous Peoples, who asked to put in place a moratorium on carbon markets. Also very relevant is referring to what Richard and Gasly said, the participatory assessment of the carbon market. So now we are foreseeing some impacts, but it would be good that the national human rights institutions and the competent authorities can also look, which is this impact. And of course, as Gasly said, also promote other community-led models to reduce greenhouse emissions, to protect and restore ecosystems and biodiversity, and to promote more sustainable food systems. And we think that at the international and regional level, it would be important for the human rights institutions to develop guidance for the respect, protection, and fulfillment of human rights in the context of carbon markets, including in the connection to digitalization, and to put particular attention on the situation of these rural communities and the indigenous peoples as well.
Thank you. I think with these interventions, we have hopefully a clearer picture of what we talk about when we discuss carbon markets and carbon credits, what are the key human rights violations and stakes, and hopefully what the role of human rights institutions are. And now looking at Professor Morgera, the Special Rapporteur on Human Rights and Climate Change, you've recently been appointed. You have presented very recently your first mapping report, and you do look at carbon credits briefly in your report. So this is something that we imagine it's something that you would like to explore further. So we will begin to hear your reflections on how you see your role as Special Rapporteur in addressing this issue, what the stakes are from on your own perspective. From our side, Special Rapporteurs play a very important role in kind of translating these complex and technical issues into the human rights world. When we talk about climate mitigation, carbon credits, loss and damage, of course, they don't come from a human rights space. And so the role of Special Rapporteurs is also to translate them in human rights language, and vice versa, then to translate what Special Rapporteurs and other human rights institutions say into the relevant policy frameworks. And what we heard from Ghazali about what's happening at UNFCCC in the Climate Convention is very telling about the importance of different fora to really talk with each other and inform each other. So over to you, Professor, for some reflections on your side.
Well, first of all, I would like to thank the organizers, but also congratulate the panelists. This is really essential work. And maybe the first thing I should say is that we still need much more information and independent research, ideally community-based and participatory research to really understand this phenomenon. Because while we have a pre-existing evidence base that was referred to with the clean development mechanism, while we have some understanding of the regulated carbon credits, whenever I engage colleagues who are climate experts and ask them around this phenomenon, they always say, well, these are voluntary carbon credits. You know, the information is not available. It's very hard for researchers to have a very thorough understanding of trends. So I think all the work that has been shared today is crucial, very timely, and hopefully many other colleagues in civil society, in the research community, and I think donors should really support those initiatives. I think the colleagues that preceded me did an excellent job in already linking the problems that have been identified and the problematic lived experiences of those communities that have already been involved in carbon credits projects with human rights. My recent report to the Human Rights Council simply brought together the work that has already been done by different human rights special rapporteurs and also by the treaty bodies in this topic. I think it's incipient work, but as the colleagues already said, it has been really important to identify both what human rights issues are arising, if not human rights violations, and also what human rights standards need to be applied. I think maybe before going into the details of what has already been done and what I wish to do in the rest of my mandate, I think it is important to place the question of carbon credits into the broader context of climate financing and mitigation. So I think Francesca already alluded to the fact that this whole idea of engaging in carbon credits is a way to facilitate progress in climate mitigation. However, this remains quite unfounded at the moment. But I think the other question there is with the limitations and challenges, and I think also the potentially already quite clear mismatch between where climate funding is going and when it's needed. There is, of course, an additional pressures on developing countries to engage in carbon credits as a way to make up for what is not coming their way in terms of needed climate financing. So it's important, I think, to keep in mind what are the pressures around the engagement with these processes. Now, the Office of the High Commissioner for Human Rights has also done very, I think, valuable work and is continuing to do very valuable work on this topic, both in terms of raising attentions to the question of environmental integrity, also documenting human rights violations that have to do with displacement and the lack of respect for indigenous people's human rights. And I very much agree with Anna Maria's assessment that maybe we need even deeper work now in terms of also respecting the UN Declaration on the Rights of Peasants. But clearly those questions that we have seen actually time and again in many other extractive sectors of environmental and social impact assessments, of free prior informed consent, inappropriate consultations, and eventually fair and benefit sharing are the usual, I think, critical aspects for any project to be human rights compliant, particularly when it is happening in or near indigenous territories or local territories. And I will say a bit more about that just because that has been my own research for 10 years before taking this role on. But just to say, other special rapporteurs have sent messages prior to climate COPs to really call for the need for both safeguards and effective compliance and redress mechanisms. I would just stress from my side that this is the bare minimum we need, and it's still kind of accepting that this is something that's going to go ahead no matter what, and trying to limit damage. I don't think that, of course, that is essential. We want to prevent any further human rights violations, but that already gives an indication this might not be a human rights-based approach to climate mitigation and climate solidarity and cooperation. I'm very grateful that other panelists have already reflected on the important work of the Special Rapporteur on Indigenous Peoples' Human Rights, a recent report that has gone into even more details around what would be the necessary cautions for any carbon credit project to be acceptable or even like acceptable to be considered in indigenous territories. And again, I'm thankful to the speakers for also mentioning that he has suggested a moratorium while the conditions are not in place. But in addition to that, I think he has identified a few other layers of obligations that need to be put in place, which maybe haven't come up yet in our conversation. And that's to do with, for instance, ensuring indigenous knowledge and other relevant knowledge, I think both in the governing bodies of possible carbon credits and in the validation and verification bodies. And I think in a way, the whole concept of carbon credits is very much coming from a certain worldview, from a certain idea of development, which maybe intrinsically is not compatible or is very much at odds or puts a very strong pressure on other worldviews and ways of living. And the power imbalances also come from knowledge hierarchies, or in fact, the absence of different knowledge systems that can be there at the very inception stage and thinking at the international level. The second is also a point of understanding how, while in some countries we may have strong national legal frameworks, in many we do not have clear or sufficient legal frameworks related to the protection of indigenous people's rights and peasants' rights. In many countries also have issues around responding to the self-identification of indigenous peoples. So that is a very complex legal landscape at the national and local level, which in and of itself makes any land-based, and I will add potentially ocean-based project a very tricky one to ensure protection of human rights. And that maybe is a challenge that should have been put much more at the forefront of those discussions. And finally, I think the last point, which is, I think, the one that where we need to look afresh at that idea of safeguard, is that the project should be not only agreed by indigenous peoples or peasants, but in fact should be led by them if they are in line and fit into their worldview and projects of their own development. And this is where I think we need to think about the process of participation and that idea of benefit sharing in a much deeper way. And my own work research in the standard of fair and equitable benefit sharing, both in international human rights law, but also in international biodiversity law, is that we usually think about it as something that comes after there's been consent and, you know, how it is captured in a benefit sharing agreement. But we have plenty of examples, unfortunately, and this goes into more traditional sector like mining and logging, where the whole conversation of benefits, it's already very much captured in a context of lack of access to very basic public services, and where instead of having a conversation at the outset around what would be even benefits, if any, of that project from the perspective and worldviews of indigenous peoples or peasants, we are in a situation of already being faced with a project that will go ahead no matter what, and where we're just trying to limit damage. And so to me, the whole idea of like genuine fair and equitable benefit sharing means that this is an intrinsic element of free and prior informed consent. And whether we have a process, what is on the surface of it a consultation process where we don't have that real dialogue on what will be the benefits, if any, not just a limitation of damage, we're already kind of falling short of the need to protect human rights. And so maybe just to conclude that carbon credits are now increasingly being explored also in the context of ocean-based climate action, and there is a very clear risk of the past mistakes from earlier either REDD+ or CDM projects to be applied the same in the context of the ocean, where we have less awareness of climate change, less awareness of human rights, and where therefore we have also, I think, higher risks of fragile and less known ecosystems at stake, and less understanding of the human well-being interdependencies on healthy oceans, and therefore the need to protect our human rights in that context.
Thank you very much. I'm very sorry that time is up. We were hoping to have some time for question and answers, but please stay available to engage with you if you have questions outside of the room. In any case, the idea of this side event was really to start discussing more proactively and consciously the question of carbon markets, and so really going beyond just reaffirming the need for mitigation, but addressing all the many ways in which mitigation can happen and identifying the real solutions that we can put in place. So a lot can be done with the Council. There's a resolution on human rights and climate change that is being discussed. We regret to see that it's not nearly ambitious enough to reaffirm the importance for effective and rights-based, science-based measures to be taken, but we really hope that also with the contribution of the Special Rapporteur and many other human rights mechanisms, also the political will to advance the conversation on climate at the Council will be further. Thank you very much again, and so we'll look forward to continuing the conversation in other circumstances. Thank you.